time. All right, we're going to take up first H-289, an act related to professions and occupations regulated by the Office of Professional Regulation. And Amran is with us. So Amran, why don't you walk us through this bill? Tell us what it does and why it's in finance.
Certainly. Thank you. For the record, Amran Aberjali, Legislative Counsel. This is a rather lengthy bill that covers a lot of topics that are governed by the Office of Professional Regulation. I will do, unless there's a preference for going more high level than even this, I will just do a brief explanation of what's in each section and then pause in the sections that have a fiscal impact, if that makes sense.
Yeah, I think that works.
Okay. So first, I'm going to start with the H-289 as passed by the House. This should be posted to your webpage.
Yeah, it's here.
Okay, great. So beginning with section 1, this section adds a couple of, one clarifies the language around cosmetologists to state barbers and cosmetologists rather than cosmetology, and removal of the word board for some of these because they are not governed by a board. And then, as you will see further down in this bill, this would add well drillers to the professions that are governed by the Office of Professional Regulation.
Now, we just did that. We did that last year, didn't? I remember the discussion on well drillers. Maybe it didn't make its way all the way through.
I'm not sure what happened last session, but this.
Okay, yeah, but I do remember a whole discussion on well drillers. Okay.
All right. So section 2, this is the section on duties of the Office of Professional Regulation. This just adds a section about the director of OPR may evaluate apprenticeship programs recognized or administered by the Vermont Department of Labor, Agency of Education, or U.S. Department of Labor to determine equivalency to credentials required for professions attached to the office. And then on page 3, there are some updates in this section to specify that the office can do some inquire into the criminal history background for individuals who are looking to renew any office issued, to apply for or renew any office issued credential, including a license, certificate, or registration or specialty designation for these certain professions listed on page 3. Then in section 3, in subdivision 11 on page 4, this is to require that with an application, the applicant must include a personal attestation or either by the applicant or by an authorized officer of an applicant corporation as to the representations therein. Then in subsection G, there's some clarifications here in how OPR staff is used during hearings at OPR, and there are no fiscal impacts to this. This is just better conforming with how the office uses its staff and how they use hearing officers versus legal counsel and other staff. So that moves into page 5. Section 4 on page 5 would add a new type of unprofessional conduct, which would be engaging in conduct of a character likely to deceive, defraud, or harm the public. Section 5 on page 6 adds a discipline subchapter relating to the licensure and regulation of pharmacies. This outlines this adds within the statute unprofessional conduct around introducing or enforcing policies and procedures related to the provision of pharmacy services in a way that results in deviation from safe practice. So you'll see there the new definitions of what constitutes unprofessional conduct for a pharmacy are outlined on page 6 and into page 7. And it would also, in subsection B, it addresses drug outlets that are under a common ownership and constitute control of a chain. So there's a discipline section particular to drug outlets under a common ownership and control. Section 6 is acupuncture, and this is a short one. This on page 8, you'll see it just removes Chinese herbology from the list of subjects on the examination for licensure. In section 7, this amends the definition of practice of permanent cosmetics. This is within the tattooists and body piercers chapter, to specify that microblading is included within the practice of permanent cosmetics. On page 9, there's a clarification around shops. This is also within the tattooists and body piercers chapter, to specify, and this begins down at the bottom of page 9, that a cosmetology shop licensed under chapter 6 of this title may provide permanent cosmetics services by a person licensed under this chapter without obtaining a second shop license for that premises. In section 8, this is regarding nursing home administrators. This would allow the Office of Professional Regulation to approve remote supervision as well as on-site supervision as part of the administrator and training program. This is in variance to the current rule that's in place, but was designed to address both advances in technology and the circumstances of the pandemic where in-person supervision was more difficult. And this is
Madam Chair?
temporary.
Yes.
Can I ask a quick question as we walk by something here? Ms. Aberjali, there's a word in this section, a preceptor. Can you tell me what a preceptor is? It's not I don't know what, I'm not familiar with the term.
And unfortunately, I cannot give you a good definition. I believe it is I wish we had the director of OPR here, but I believe that it is a currently practicing nurse administrator who is there to act as a preceptor towards people who are in the training program.
Okay.
If that
Great.
makes sense.
If it's anything other than that, can you just let me know? Thank you.
I will.
Great. Thank you.
Okay. I connect that word with college exams for some reason, but I don't know why. Okay.
Shall I
Section-
continue?
Yes.
Okay.
Well drillers, there they are.
Well drillers. So the next couple sections are for the purpose of moving the licensure of well drillers from within the Department of Environmental Conservation at the Agency of Natural Resources into the Office of Professional Regulation at the Secretary of State's office. So this would add a new chapter to Title 26. This would be Chapter 107, Well Drillers. You'll see there's definitions starting on page 11, moving down through page 12. I would say the bulk of this language is copied over from where it currently is over in the Department of Environmental Conservation in statute. There are some there are some changes in order to conform it to sort of the standard regulatory framework of the Office of Professional Regulation. Say that this section is one of the sections of the bill that does have a fee, or I should say
now
really
I know why we have it.
a change in a fee. I do not recall what the current licensure renewal period is, but I do know that in section 5609 of this, which I will scroll down to, it is on page 5609, is on page 19. So a license shall be renewed every 2 years. Upon application, payment of the fee required in accordance with Title III VSA 125, which is OPR's fee statute. So there is a change. The fee will change with this shift, as I believe it is both slightly lower, but also the timing of the fee changes from either, I don't recall if it's once every year or once every 3 years, but it's moving to a 2-year renewal.
Because, so we know what we're changing from. This tells us what we're changing to.
Mhm.
But if you can find us the present statute, I think that might help us get this out of here.
Okay.
Because if we're keeping the same fee and cutting the renewal time in half, it's really doubling the fee. I think we should know that.
It is, I do recall that it is not doubling the fee. It's
doubt it.
within Title 10, where it presently is Title 10, Section 1395A, licenses and rules. So I can check on that with you. I believe that the end result was that the fee was going to be a little bit lower than it currently is, even taking into account the
I
shift in
have
the
a
time
feeling
frame.
Senator Hardy has found that. No?
I'm looking for it, Madam Chair. But I do have a question for Amarin,
Okay.
if I may. Amarin, so it looks like the licensure duties right now for well drillers rest with the Agency of Natural Resources,
That is correct.
and it's moving over to OPR.
Yes.
That in this bill, is it just moving over basically the exact language and then conforming it with the OPR statutes?
For the most part, there were some small changes, but most of the language is coming directly over.
Okay. And the other responsibilities for well drillers though remains with, is it DEC and Agency of Natural Resources?
I'm not sure I know what you mean by other responsibilities.
Well, like the statutes that talk about drilling wells and water quality and all
That
this-
all remains with DEC.
Okay.
This
so
is
it's
just the licensure piece.
the person and whether they're qualified to do the work, essentially.
Correct. This does
Okay.
not change the regulations for the performance of the well drilling
Right.
itself.
Okay. Got it. I will look for the fee question, Madam Chair.
Then Amarin can keep talking to us. Okay.
All right. Let me return to, oops, I think I shifted my screen. Okay. So we were in,
I think we're in section.
okay, so we were in section 5609. Is there any interest in going over more of the well driller sections, or?
I don't think so. Our jurisdiction right now is that fee unless there's more in there.
I do not believe in the well driller section there is
Okay.
not.
All right, so we may have another fee in here. Okay, let's keep
All right.
moving.
So section 12 transfers the rules that are currently in place at the Department of Environmental Conservation pertaining to the licensure of well drillers over to the Office of Professional Regulation. And those will remain in effect until OPR is able to adopt their own rules governing the profession, the licensure of the profession, I should say. So section 13 is a shift over to the Agency of Education, and this would take part of the appeals process from the State Board of Education and have that piece of the appeals handled by the Office of Professional Regulation. And this is primarily due to the infrequency of these appeals reaching this level, in which case this State Board of Education typically has to then orient themselves as to how these appeals work, perhaps hire counsel to assist them with that, whereas the Office of Professional Regulation handles many appellate hearings. And so this is one piece that is being moved over to the Office of Professional Regulation. And you'll see if you scroll down to page 22 in section 14, this does require the Agency of Education and OPR to assess the costs and benefits of transferring more of those educator discipline responsibilities over to the Office of Professional Regulation. And so that's a report back, excuse me, on or before December 15th, 2021. So that is the end of the as passed by House version. And then there is a rather substantial amendment that's being recommended by Government Operations.
Okay.
Looks like we'll
I'm
have
sure. Can I
hands.
ask a quick question? I'm sorry, there's other hands up too. I didn't see.
Okay. No, Senator Bray, and then we'll go to Senator Sirotkin.
Just to, Ms. Abergilli, so 1707, appeal from panel order. So the panel that's being referred to is what panel?
Sorry, let me scroll up. You are looking at.
It's just the lead-in language. It's appeal from panel order, and we're going to OPR, but I don't know where we're leaving.
Okay, that is also still at the State Board of Education, the
Okay.
hearing panel. You have the first level of appeals that's still handled, and then this would be the next level of appeal.
Okay. So
From
for
the hearing
instance, if
panel.
someone alleged improper conduct by a teacher, this is the panel that currently would hear such a thing. And now we're saying
Yes.
for an appeal of a decision of that board, go to OPR instead.
Yes.
Okay.
And you know,
thank
I misspoke. I'm not certain that the hearing panel is at the State Board of Education, but it would keep those current appeals, that first step of appeal where as it is currently conducted. The only change would be that higher level appeal.
Okay. Thank you.
Okay, so let's see what.
Oh, wait, Madam Chair,
Yes.
Senator Sirotkin had a question, and then
Oh,
I
Senator
do
Sirotkin.
too.
You're right.
Thank you, Madam Chair. Probably not in our jurisdiction, but I was just curious, is there any kind of amendment from Government Operations on the pharmacy piece?
No, there is not.
So my question on that piece is, I'm concerned from a legal perspective. It seems like it's sweeping in all kinds of chain, or however you want to name it, pharmacies, where I'm not sure there couldn't be different kind of ownership structures where even though you're using a similar name, there's primarily in control of an independent owner, and yet they could be saddled with a disciplinary action against a bad apple that has the same name. Was that discussed anywhere?
That was not discussed, but OPR's jurisdiction is over individual pharmacies within the state of Vermont, not over a chain. So the investigation into misconduct is going to be at specific chains. And if they believe that what is happening at one pharmacy may be occurring at other pharmacies that are in some way related under common ownership to that chain, then they would be able to, within that same case, look into those other pharmacies. So what I'm hearing from you is a concern maybe that a pharmacy that might have a similar name might inadvertently be thought to be part of a group of pharmacies that are under common ownership. Is that the concern?
Yeah, sort of. I mean, if I read the language, it just seems pretty loose in terms of being able to sweep in and almost, I'm not sure it distinguishes really between the two situations where there's common ownership and where there's like a franchise in just a name. But let me look into that offline, okay?
Okay,
Sure.
that would be good. Okay, so let's walk through and see what Senate Gov Ops changed. Unless they've added a fee, our jurisdiction is one fee.
They have added fees.
They have added fees, okay.
Can I just get one clarifying question?
Yep,
Ameren, in the section about the appeals panel, I had the same question as Senator Bray. I was confused as to what that panel was, but it says educators. Does that cover, that's broader than just, is that broader than just teachers? Does it encompass principals and superintendents and other, or is it just the sort of classroom teacher level?
I will have to look that up for you. I do not know offhand which. I can check with the director of OPR, who I know has had extensive conversations about this, and look at the statute and see which professions specifically the educator is referring to.
Okay. And the report is just about transferring disciplinary action, not full licensure action, basically, like the application for a licensure and the credentialing for a license and all that stuff. Is that correct?
This is just looking at responsibility for educator discipline, making investigative and disciplinary processes.
Okay.
So.
Okay.
Yeah.
Great. And I cannot find a fiscal note on the bill anywhere. So I don't know if one existed at some point regarding the fees. So that's what
I would doubt it. If they just got added.
Yeah.
Okay. So Ameren, why don't you walk us through what they did, and maybe we'll have something more interesting to look at for us.
All right. So now I am switching over to the Senate Government Operations Amendment, which is draft 1.5, which is also posted with your materials for today. And I will just take a moment. If people could just give me a nod or a wave when they have the document. And I will begin.
I think you're ready.
Okay, perfect. So the first instance of amendment would be to make a change in section 1. And this is in order to, in addition to making those changes to the list of professions that are under the jurisdiction of the Office of Professional Regulation, this would also change the nature of the director of OPR position from an exempt position into a classified position. So that is one change. And then the second instance of amendment would strike out the effective date and then add in the next sections 15 through 21. First, this would add mixed martial arts as a profession that is regulated under Title 26. Would also move boxing into this new chapter. This would be a chapter 107, boxing and mixed martial arts. There would be the subchapter 1 boxing, which is currently in Title 30 or 33. I'm forgetting now at the moment, but it's taking that language verbatim and moving it over so that it is with mixed martial arts under Title 26. And then it would add subchapter 2 that is specific to mixed martial arts. You'll see section 6025 starting on page 2 is definitions for this subchapter. Section 6026 on page 4 outlines OPR's jurisdiction over mixed martial arts events and licensure for mixed martial arts. Section 6027 outlines the director of OPR's duties for this subchapter, which is this language is fairly standard for each profession under the regulation and requires that, under Titles 26, and requires that the director adopt rules for the performance of the duties under this subchapter for the Office of Professional Regulation. In section 6028 on page 6, you'll see that the Secretary of State has to appoint 2 individuals to serve as advisors in matters related to mixed martial arts regulation. And then in section 6029 on page 7, you'll see that there are certain types of events that are exempt. You'll see that all amateur mixed martial arts events are regulated by OPR, except for amateur mixed martial arts events conducted by a school, college, or university. And then in subsection B, you'll see the director by rule may exempt the application of these rules to mixed martial arts events in which there is minimal or no contact between contestants, for which there is no remuneration for participation, and for which no tickets are sold or admission fees charged. So beginning in section 6030 on page 7, this is where we begin seeing the licensing for a variety of types of participants in the MMA events. There will be contestants, promoters, other participants. I would say you'll see reference in here to fees in each of these sections, although the fee section itself is a bit further down. So you see there in section 6030, subdivision 3, a fee may be assessed for a contestant license in accordance with 6033. You'll see there's a medical exam report for contestants as well. And so you'll see there are, I don't think this quite falls under what you mean for fees, but there are fees for the pre-match examination, which are to be paid by the promoter of the match.
And I assumed that that Senate GovOps did not create this whole cloth, that it was a recommendation of the department.
The Office of Professional Regulation did come forward with some proposed language for Senate Government Operations to review.
Okay. And are mixed martial arts under anyone's jurisdiction now?
No, they are not.
No. Okay. So this is a new regulation. Okay.
Yes. And it's my understanding that much of this was put together from a survey of looking at other states that currently regulate MMA events and licensure.
Do we have MMA events?
I'm sorry?
We do. Okay. I just hadn't seen them advertised, so, but yes.
There was a fairly high profile and controversial event that may have sparked this. I believe it was in Rutland County during the pandemic, and it was not only not following COVID regulations, it was also not following other regulations, and it involved some pretty young children as well. So my guess is this is coming out of that pretty high profile case.
Okay. That answers the why. All right.
So let's see, moving down to, okay, so yeah, so in section 6031 on page 9, this is about promoter licensure. So you will see that there is also a fee for promoter licenses. That's in subdivision 4 on page 10. And then you'll see in subdivision 5, before any promoter license is granted or renewed, the applicant shall execute and file with the office a bond to the state in the amount of $10,000 to be conditioned upon the faithful performance of the applicant of the provisions of this subchapter and the payment of the taxes imposed under the subchapter. The bond shall be in a form with sureties satisfactory to the office, and no promoter license will be renewed unless the bond has been renewed and filed with the board.
Okay. So there's a bond. What are the taxes?
We haven't quite gotten there yet.
Okay. Okay.
There's a lot in here. So you'll see in subsection B at the bottom of page 10, there also needs to be an event license in addition to a license for those individuals who are participating in the event. And so a fee may also be assessed for the event license itself. That's in subdivision 2 on page 11. And you'll know that the office may charge a separate event license fee for each day of an event. In section 6032, this governs the licensure of participants. And again, in subsection B on page 12, a fee may be assessed for a participant license. And then fees are outlined in section 6033, which begins now on page 12. So you'll see for application, there's a promoter license fee of $500, an event license fee of $250, a contestant license fee of $25, participant license fee of $25. And then moving on to page 13, there's a biennial renewal for managers, seconds, referees, and judges of $25. Biennial renewal for promoters is $500. An annual renewal for contestants is $25. And then there are late fees that may be imposed pursuant to OPR's current late fee schedule, which is in Title III, Section 127D1.
Okay, I had one question. There is an event fee, but you said earlier that the event fee could be charged for each day of an event. Who makes that decision and on what basis?
It is not addressed in these statutory provisions, so I am assuming that that would be addressed in OPR's rule for regulating this profession.
I'm a little concerned about that. Senator Sorokin.
I picked up on the same thing. I share your concern. Is there something in here that requires rules? What if they don't promulgate rules?
There is a section on rules. This is back up in section, I believe this is around, okay, this is on page 5, subsection B. The director, in consultation with the advisors appointed in accordance with this subchapter, shall adopt rules necessary to perform the director's duties under this subchapter and shall establish safety standards for the protection of contestants, participants, promoters, and the public. The rules adopted by the director shall at a minimum include the following: rules for the conduct and holding of amateur and professional MMA events, requirements and qualifications to be eligible for licenses for anyone involved in MMA events, including promoters, contestants, participants, and to be eligible for event licenses, requirements for the collection, retention, and remission of bonds. And now on to page 6, requirements for promoter reports to the office, including reports following an MMA event and for promoter payment of the event tax. Requirements for medical examinations of participants and contestants, requirements for medical examinations of contestants and participants before, during, and after MMA events, exemptions for certain MMA events, requirements for the inspection of facilities, and all other requirements necessary for the safe conduct of MMA matches and events.
So I'm not seeing in here any mandate for rules for coming up with daily fees for events.
I think, yeah, I would say it is not addressed directly. I would, looking at this, probably put it in subdivision 2, requirements and qualifications to be eligible for licenses for anyone involved, and to be eligible for event licenses. But you are correct that it does not
Criteria
explicitly address.
Yeah, criteria for charging for a daily fee. I would think that would have something to do with the size.
Right. Whether it's a week or 2
Yeah.
days or a month. I don't know if it could be put in this section just read here. I don't think we want to prejudge what they're going to come up with for a rule, but I think they should come up with a rule. Otherwise, as the chair says, there could be silence on it, and who decides what the fee is for a multi-day event.
And it's not an insignificant fee.
Right.
Okay, so maybe if we could get an amendment, just making it clear that they are to write rules setting the criteria for when a fee will be charged for each day of an event.
All right.
Okay.
Okay. So let's see. Shall I continue on, or are there
Yes,
more
this,
questions?
you've
Okay.
mentioned an event tax.
Yes,
Is there's a tax coming up?
there is.
Okay.
So you'll see in section 6034 on page 13, these are provisions around renewal of licenses and deadlines attached to those license renewals. Section 6035 has requirements for medical insurance. Section 6036 has requirements around medical examinations for contestants, both before, during, and after a match or event. Section 6037 on page 15 outlines requirements for having a referee at an MMA match. And 6038 is about having a physician in attendance at MMA events, as well as having an ambulance at every MMA match. And then the tax post-event report by promoter section on page 17, section 6039. Subsection A, every promoter shall, not later than 7 days after the conclusion of an MMA event, submit a post-event report to the office in accordance with rules adopted pursuant to this subchapter. The report shall include the exact number of tickets to the event sold, the amount of gross and net receipts from the event, and any other facts as the director may by rule require. The promoter shall report on tickets sold to an entire event, not to an individual match within an event. Subsection B, every promoter shall, not later than 7 days after the conclusion of an MMA event, pay to the office by certified check a tax of 5% of the receipts from tickets, admission fees, and sponsorships after all costs from the event and any other state and federal taxes thereon have been paid. The promoter shall pay the tax on the receipts from the entire event. This tax shall be deposited in the professional regulation fee fund and used to carry out the provisions of this subchapter. Subsection C, if the report required under this section and the accompanying tax are not paid within the 7 days required, the office may examine or cause to be examined the books and records of the promoter and any corporation on behalf of which the promoter held the event. So that is the tax event fee section.
Our next group of witnesses is arriving. Senator Pearson.
Thank you. Ameren, is this modeled like after boxing matches or anything that's commensurate?
I believe it is after the boxing chapter.
Okay.
But
I have
there
down that we're
I
gonna
should
need
say,
yeah.
I should
We'll
say there
hear from the
was,
juror.
I'm sorry.
Go ahead. No,
There was a discussion between OPR and witnesses sort of offline to collaborate a bit on this language. And so this is the result of that. But I believe in terms of the method of collecting and where the funds from the fines are deposited is based off of how it is done for the boxing chapter.
Okay. We'll have the tax department in and the director of OPR to talk to us. I thought this might be something we could vote out today, but it's not. Senator Bray, and then I've got Senator Sorokin.
Muted, there we go. Was there a sunrise study or something like that? Is that why this came up for legislation?
I am not sure if this was part of that report.
Okay.
I-
All right. And the structure where there's fees for the contestants as well as a tax on the event, is that too comparable to how boxing is handled?
I do not know.
Okay.
We'll find that out.
And the last, I'm trying to remember, my thought was whenever we use the word fee, I'm always thinking that this is simply designed to cover the cost of administration. And it seems like there's a lot of fees here, but maybe it is an expensive program to administer. I don't know if, well, I guess, I don't know who can, it'd be OPR that would have to speak to that
Yeah.
point. Okay.
We'll have them in and we'll find out. Okay, everybody. Senator Sorokin, I have next, then Senator Brock and Senator Hardy.
So following up on Senator Bray's question, is there a requirement in law right now that before we license a new profession that you have to go through a sunrise report? And do we need a notwithstanding clause here if we didn't?
I am not sure if there is a requirement for that. I don't believe that it's required that it go through the sunset report, but do you
Okay.
mean the report that the Office of Professional Regulation does on recommendations for the scope of regulation?
Yeah, sunrise. I thought
Sunrise, excuse me.
we passed something a while ago that said you had to do that, but I could be wrong. And what's going on here is that we're charging a 5% tax. Do they not already pay a sales or some sort of tax on, like when someone goes to the Flynn Theater, you don't pay tax on those tickets?
I believe that this is in addition to other event taxes.
Okay, and those other event taxes would be our normal 6% or 7% in the case of local option tax?
I am not sure.
We'll have the tax department in to talk to us.
Thank you.
Okay, Senator Brock and then Senator Hardy. Randy, we can't hear you. You're not muted. There you go.
That time?
This time we can hear you.
Okay. In this bill, and I didn't notice it, are there anywhere any provisions for additional staff being required by virtue of the new professions that are being regulated or the changes in regulation?
There is not anything in here for new staff.
And if you take something like the well drillers that previously were regulated by another agency, are there additional costs that are incurred here that were not incurred with the regulation in the other agency? And do we have any idea why?
I do not know, but the Office of Professional Regulation Director will, I'm sure.
Okay, thank you.
You're welcome.
Okay, Senator Hardy.
Thanks. So speaking of the director of the Office of Professional Regulation, she's listening. I'm sure she's writing down all these questions.
I wouldn't be surprised.
She did email me regarding the well drillers fee. So I'll just read to you what she said. She said, currently well drillers renew every 3 years in which they pay in yearly installments. each year is $140 or $420 total per cycle. They will pay $240 at OPR, which we will collect every 2 years. So the fee is reduced by $20 per year. So it's a slightly different cycle, but overall it's a lower fee by moving.
Lower fee, all right. No one will complain about that.
And she did confirm that there is not a fiscal note on this bill. So it would be helpful to get more of a big picture of what the finance.
Yeah, I think we
are.
will, if Faith can just email over to JFO and ask for a fiscal note.
That would be great.
Okay. All right. So I think that's it. We will definitely invite the director in, and we'll invite the tax department in, and see if they can tell us. We're interested in what this whole system is modeled on and why it's coming up now, without what sounds like a sunrise. And we will, I think, be moving on. Any questions you have, let us know and we'll find somebody that should have the answers. All right. Okay, on to fun and games. This is H431, miscellaneous energy subjects. And I thought this was a simple little bill. And then I thought that Senator Bray, that there was a request for an amendment by the Natural Resources Committee, but it's now my understanding there isn't. There is an amendment by Senator McDonald, which has set my emails going. So Senator Bray, does Natural Resources have a request for any change?
No, as a committee, we don't have a request. So we had some testimony on standard offer. I don't know.
Not shutting you out. I'm just trying to eat my lunch.
Okay,
I'm
2 or
here.
3 weeks ago, I forget. And so there was some offline discussion here and there. Senator McDonald took the initiative to bring forward some an idea and some language last Thursday, which was our last regular committee meeting. And but it wasn't drafted by Ledge Council yet. So you could, I think it was referred to as an off-campus proposal of amendment. We looked at it. We had both interest and some concerns about it. But again, it wasn't a formal amendment at that point. It was more of a concept of what could be an amendment. And then that was really the last that the committee, has talked about it. And then I believe what we're going to see today, we didn't actually, it was just introduced today. So it will be new to me. So in other words, the committee's, Senate Natural was interested. We had some concerns about different aspects of the concept as floated out. And then we shut down, and now we're going to see an amendment that may reflect some of those concerns or interests that came out in the committee.
Okay. My recollection, and I don't know where I heard it, was that the standard offer program was slated to end January 1st. So if we didn't do something, then it would be gone. I think when I talked to you earlier, you said that wasn't the case. So can you let us know what that is?
Sure. So the department can speak definitively to this since they're involved in the administration, and as is the PUC. But the characterization of what was going to happen to standard offer and when was a little murky. So I got in touch with the PUC on Friday, and in short, they're preparing to have an auction of capacity, more jobs bid this year. So summer 21, The bill will allow them to bid again in summer of 22. And then it's possible, if you win a standard offer, a bid, but you don't construct something after a time certain, your bid reverts, those megawatt hours you quote unquote won, revert back to the program and they can be rebid. So we know at this point that in 21 there'll be an auction, in 22 there'll be an auction, and it's possible that some hours will revert and there'll be an auction even beyond 22, but it's certainly not certain. That's just sort of cleanup.
Okay, Senator Pearson.
So if we do nothing, there'll be an auction next summer. I thought it expired next winter.
So they prepare, again, department can speak on the exact timeline, but as I understand it, they're preparing an auction now for this summer, 21. They'll be doing the same thing a year from now for the summer of 22. So I think what was unclear to the committee when we had a discussion was if we didn't act, would we cause there to be a gap because they would have sort of quote unquote gone out of business before we would act again. That does not appear to be the case. I suppose the other thing too that we hadn't really got into in committee is because these bids are for 25-year commitments, obligations, the administrator of these auctions, has to maintain all those bids. So there'll be an entity operating to maintain the contracts for the next 25 years as well. So, so there's two pieces to the story.
Okay. So maybe, there it goes. Ed McNamara is here, Director of Planning for the Department of Public Service. And I think Ed is here. Yep, there he is. So Ed, can you just kind of walk us through what is the present situation? What happens if we do nothing? What do we have to do? I think, judging by my emails, this has become a little more controversial than I thought it was, and I don't really want to take action if we don't have to. So the floor is yours.
Great, thank you. For the record, Ed McNamara, Director of Planning, Department of Public Service, and I'll try to do this fairly quickly. So if there's any questions. So the program, the existing statute says that the Public Utility Commission shall issue standard offers, essentially requests for contracts for 127.5 megawatts of resources. These resources have to be 2.2 megawatts or less. So currently, standard offer program uses a reverse auction or an RFP mechanism to procure the resources, with the PUC establishing an upper price limit for the bids. And there's also several technology-specific categories within the program. Solar is the most predominant resource, but there have also been a decent number of small wind projects as well, relatively small capacity individually, but a fair amount in terms of the number of projects. Part of the confusion here is it's a stepped program. The way that the language is written, it has the 127.5, but then the statute also says PUC shall issue standard offers for 5 megawatts per year for 3 years, 7.5 megawatts per year for 3 years, and then 10 megawatts per year thereafter until you reach 127.5. So it's actually the 10 megawatt category. There's 4 years of that. And I think most people simply looked at 3 years for 5, 3 years for 7.5, and then extrapolated it to 10. So as Senator Bray noted, there is an RFP probably early this summer, and then another one either spring or summer of 2022 to get to the 127.5 megawatts. Excuse me. Also, Senator Bray noted that some projects drop out of the queue, and there are backup or reserve projects that are listed when the PUC selects projects. So it's not entirely clear that there would need to be a procurement in 2023 as well. And I probably won't know that until next year at the earliest. So there is a little bit of uncertainty there, but we do know that there will be at least two more procurements on this. Some other factors, standard offer centralized procurement process, third-party administrator that's under contract to the PUC. A standard offer facilitator is responsible for issuing the RFP, recommending project selection, but the PUC makes all the substantive decisions about this. Just for context, in the last year's RFP, the 2020 RFP, there were 14 projects selected, and the prices ranged fairly considerably depending on technology category. So the lowest price was a Green Mountain Power project, solar project at 8.7 cents a kilowatt hour. And the most expensive, there was a number of small wind projects that were 25.8 cents a kilowatt hour as well. It's just as a reminder, the costs and the benefits. So in other words, the products, the capacity, the energy, the renewable energy credits, those are assigned to utilities based on each utility's pro rata share of load, with the exception of Burlington Electric Department, Washington Electric Department, and Village of Swanton Electric Department are all exempt. They're 100% renewable with respect to both renewable energy credits and the underlying energy as well. This exemption is closed, so those three utilities are not going to receive any of the costs or products associated with standard offer. Also important to remember that the renewable energy credits, the RECs, from any project built after any standard offer project built after July 1st, 2015, can be used to comply with Tier 2. Standard offer is a mechanism for procuring renewable resources. It does not increase the amount of renewable resources in Vermont. This is something that I think there's been some confusion about. So the RECs can be sold out of, RECs that are sold out of state cannot be counted towards Vermont's renewable requirement. To the extent that in any given year, the Tier 2 RES requirement, that there are more Tier 2 eligible RECs procured. In other words, we develop more standard offer projects and have more net metering projects developed in that year than the standard offer requirement. Those RECs are either sold out of state to reduce the costs for Vermonters, or they're banked for future compliance. So increasing the amount of standard offer or changing the amount procured by standard offer doesn't actually reduce in new renewable resources. It's simply a mechanism for procuring the Tier 2 resources. In other words, if if standard offer ended tomorrow, it would have no impact on the extent to which Vermont load is renewable. One of the concerns the department has flagged with the existing standard offer program is that there's no locational signal associated with it at this point. Given the significant success that Vermont has had, I'm sorry, it looked like Senator Pearson was saying something. Oh, it's my apologies. Given the significant success in deploying distributed generation, Vermont is now at the point where additional DG can potentially impose hundreds of millions of dollars of transmission cost if we're not careful about where we actually site it. It's not a given that these transmission costs are going to show up. If we continue to site them without regard to best placement from a grid perspective, we will have significant additional costs. So the current standard offer program does not consider grid impacts in selecting projects. In fact, the department had actually recommended, excuse me, a few years ago that the PUC not allow projects in SHEI, standard offer projects in SHEI. The PUC at the time said they did not see the statutory authority to do so. They included in the RFPs saying if somebody is proposing a standard offer project in CI, you have to be able to explain what the impacts will. You have to basically explain what the cost impacts are, and you're going to have to jump through some hoops on the siting process. Notwithstanding that, there was one project that was actually proposed in SHEI, and when asked about the RFP, they simply shrugged and said, oh, we didn't see that part. So the standard offer program is not particularly conducive to looking at the locational aspect of projects. It's relatively straightforward in terms of participation for solar developers and relatively straightforward in terms of project selection based on price, but not on what the grid needs and not what benefits Vermonters in the longer term.
Okay.
Last piece I'll simply note, there's some litigation and administrative costs associated with the current standard offer program that we're actually a little bit worried about. There's federal statute constrains the ability of states to set prices that utilities will pay for resources. There's some exemptions to that. And I will also note that net metering does not fall under that because net metering is not considered a wholesale sale under federal law. It's essentially a netting or a reduction of the utilities load. Standard offer program has been challenged at FERC twice, Federal Energy Regulatory Commission, apologies. Federal District Court at least once, and Vermont Supreme Court 4 to 5 times in the past, I think 3 years or so. The litigation is about the consistency of the program with federal law, specifically around the parameters of when the state can set prices and whether an auction mechanism to set prices is allowable under federal law. So the DPS and the PUC, we've spent considerable time and money on litigating this program, supporting the program. So far, it's been only the DPS and PUC, and I think maybe Green Mountain Power participated in one litigation. Nobody else has actually even provided a amicus brief to actually support the program at any point in time. So during all this litigation, it's been the department and the PUC bearing the costs of this. Another aspect of administrative costs, this is the only program where state regulators are picking who gets a 25-year power supply contract. All other resources are procured by the utilities who have considerably more in-house expertise in selecting the resources. So it's a little bit of background on overall the department's recommendation is to not extend the program at this point in time. You have an auction this year, you have another auction next year. Those are mandated, those will happen. What's also happening at this time is there's a climate council and a comprehensive energy plan that are looking at how we actually go about achieving the Global Warming Solutions Act mandates, the GHG reductions. What are the best mechanisms for doing that? What I've heard in the context of the climate council has been, yeah, folks are going to look at the renewable energy standard. What does that look like? How do you structure the renewable energy standard? So rather than doing a one-off extending standard offer program, pushing it out for another 2 years, without the locational considerations and everything else, is discussion of the procurements, renewable procurement, should be in the context or more cohesive, coherent, and honest discussion about the overall renewable requirements of the state, including the procurement practices.
Okay. Senator Pearson, you have a question?
Yeah, thank you, Mr. McNamara. I first learned about the SHEI and the idea of a region of the state to being constrained when I sat with Senator Brian McDonald on natural resources in 2017. I'm trying to search my memory, but I don't recall any proposal from the department on how to deal with this as a state level. Can you point me to a strategy? I mean, it is one thing fair, I think, to acknowledge that impact, but it also is a problem we should solve. And I'm not aware of the department proposing anything to solve it. Am I just misremembering? Is this something we could work on for January? Where are we at with this, or are we just bound on this loop of us, some of us promoting more renewable energy and the department coming in and saying, gosh, it's hard, we're not ready for the location challenges?
So I would say the department has proposed, and we've proposed several months ago, a grid adjuster for net metering projects, just recognizing that net metering has less value in some areas. And I guess it's then becomes a question of what do you mean by solve the problem? We can definitely throw money at the problem. We can definitely spend a couple $100 million to then allow any new renewable resource to build in an area that's already 100% sourced by renewable resources. The department's view at the moment is we have not prioritized this one because all of the renewable power in Shiai, or all the power in Shiai, is actually renewable. And so spending money to replace existing renewable power with new renewable power when we've got a climate crisis and most of the emissions in Vermont are coming from the transportation and heating sector is not wise policy to the department. So we've not been recommending a longer term fix to allow new renewable generation to replace the existing.
Well, but that's so you don't really have a solution. I mean, the net metering is a tiny fraction of the problem. We have an automatic schedule for net metering to be adjusted in the economics through the PUC. So I'm pleased to hear you're taking advantage of that. But in terms of building an actual grid that would really have us be ready for the future and have us be set up to handle the unique challenges that renewables and solar present to us, where is the plan, and do you not need the legislature to be part of that plan? We'll just have to hope that someone will get to it. I mean, I really am struggling to understand this.
Yep. And so I will say again, comprehensive energy plan is due next year in 2022. You will have that. With respect to Shiai, yeah, it's an issue that's been known since 2013 and has not been resolved. And again, the resolution of Shiai, to the extent that you want to say the grid is outdated and simply needs to be upgraded everywhere, there needs to be a very open, transparent discussion about how much are we willing to pay to have new distributed solar that replaces the existing renewable resources in the area.
I would just say that's not my point. My point isn't how do we build more renewables in the Shiai. We've handled that. The department licensed those wind towers. They licensed or were party to the approval of the cap on the landfill. That you have been party to the trunk of Hydro-Quebec Energy coming in through there. You're part of that, but that's fine. The Shiai, we don't need to solve that, as you've said. Maybe we have some storage solutions that ease that. But to then throw that up repeatedly over when we're trying to build more renewables elsewhere in the state, it tries my patience. And maybe I will stipulate every time I bring this up, I will say, I don't want to build more renewables in the Shiai. Now, help me do it elsewhere, because Vermonters are ready for that. We need our grid to be modernized. We need our grid to be greener than it is. And I'm tired of hearing about the Shiai as an excuse to not make progress there. Thank you, Madam Chair.
Okay. Did I hear one of the problems was that there is no ability in this program for location to say, the project has to be somewhere outside the Shiai. And could that, if we decide to go forward, could that be a solution to make that possible?
And I would say 2 points to that. One, it's not just in Shiai where the grid is getting constrained. And in looking at the potential transmission impacts, it's not just Shiai. It's actually areas all the way down south, Addison County and other areas where generation there can negatively impact the potential infrastructure needs for transmission. What's really needed if we actually want a modern grid is to do what most other states are doing and looking at locational pricing for distributed generation. That's something where we need to do that. That is not just Shiai, not Shiai. That is some gradations as well. Some Shiai might be the lowest priced. Addison County might be slightly lower. Other areas in full value is actually looked at in terms of Southern Vermont, which is where the least impactful generation or the least impact from new distributed generation. So there's definitely mechanisms for doing that. And my concern with simply extending standard offer for another 2 years is that, one, you have another 2 years of RFPs right now. It's not going to be, what I'd suggest is let the existing standard offer program as it is now expire, and next year check in to see if there's any ideas for a replacement. If not at that point, then look at extending it there. Extending it now with no effort by any folks to actually put forward another potential program that actually acknowledges that there is locational considerations. I'm not seeing the benefit of that at the moment.
Okay. So I think what I'm hearing is you don't think any extension proposal right now is ready for prime time. That there's a lot of background work that needs to be done as we've progressed over these 25 years. Okay. Senator McDonald.
Madam Chair, I understand, and if I'm incorrect, someone will let me know, that the PUC rejected a proposal in the Shiai within the last year. And at that time, the other 3 proposals within the Shiai were withdrawn. We have had suggestions to prohibit construction there for standard offer projects. And now that the PUC has been not accepting proposals from that area, that seems to be resolved. The witness referred to leaving the purchases of power up to the utilities to make. There have been a couple examples of Green Mountain Power buying electricity in areas that were restrained. One was restrained and the other one was pushing the restraints over in Pant, trying to get through Virgins. So that doesn't seem like a solution. The auction this summer is pursuant to the existing law. So is the one next summer, but it takes, I think if someone else will come and testify, it takes a year to put a plan together to even put it up for approval. So if you eliminate the program, then people are not going to be putting stuff up for approval in the event that these proposed problems are resolved. So I would suggest that keeping the standard offer program going and allowing the PUC to continue to reject problems in the overserved areas would be both prudent and in the spirit of replacing fossil fuels with renewable energy. But I'll wait for the further witnesses to verify or comment on that. So.
Senator, we're getting way behind. The next thing on the agenda is your amendment or amendments.
Yep.
And no one has seen your amendment. So do you have a copy?
I believe Faith can put it up so you can see there were 3 proposals. There's one that I would urge that we do now. So.
Okay. Can Ellen walk us through them?
Yes, well, while they're going up, the amendment that I have proposed and is being brought up would extend the program for 2 years, would not permit an increase in the renewables. It would maintain it at the same level, and it would provide flexibility that you could build bigger projects instead of lots of smaller ones, but there would be no increase in the amount of electricity that was open to be bid upon.
Okay.
Ellen, can you put it up or? could
Okay,
Faith
Senator
put it up?
Pearson has a question. Senator Pearson.
Senator McDonald, as it happened, I watched Natural Resources last week because I had to call Senator Bray and I wanted to see when he would be off. And the committee at the time voted in favor of some language. Is this that? And I gather that's changed, but I wanted to ground it in my understanding of what I thought was a 4-1 vote in support. Is that for this language, Senator McDonald?
Yes, 2-year extension, not a 3-year extension, and no increase in the amount of electricity that's put out for bid, and to keep the level the same. And it was the support in natural resources was limited to an extension under the current level of electricity. Yep.
Thank you.
Okay. Was that under the current understanding that the program was not ending January 1st?
The program is ending on January 1st. The existing program permits bids this year. And as the last witness said, sometimes those projects are not built. And when they're not built, there is leftovers that can come up again for bid because they were not built. So, for example, if this year's bids were all taken, and last year's bids had all been taken, then we might not be looking at bids for next year. That's I'm perhaps oversimplifying.
What I heard was there was an auction this year in 21. There was one
Coming
in
up.
22, and then 23 was the year. So 2 years out before there might or might not be an auction. And I'd stand to be corrected, but that's
no,
what I heard from McNamara.
Anyone else could come in, and if you had someone to come in and repeat that.
Okay, Senator Bray, what was the committee's understanding, or has it evolved?
Yeah, so I would say it's evolved because I just want to be fair and accurate here. We didn't see precisely this language. We saw something similar and then discussed, moving a number up or down or things like that. One of the questions that came up, and we heard conflicting testimony very briefly, it was really only the last 15 minutes or so of our meeting. And we didn't have witnesses in at that moment. It was committee conversation was, well, when is this actually ending? And so that's why I went back to the PUC on Friday. And I think Mr. McNamara just said something very similar. So there is a bid going out this summer, 21.
Mm-hmm.
There is a bid going out next summer, 22. And it's possible that there'll be, I forget what they're properly called, but I've been calling them capacity that reverts for reallocation to a different winner or whatever that
Agreed.
person.
Yeah.
So I think the committee was under the impression that if we did not act, the program would sort of go out of business before the legislature would convene again and be able to take steps should it want to continue it. And I think that's it's a small but important point for me personally. I just thinking, okay, if we have the chance to look more carefully, I'll just speak plainly, I would prefer to commit to doing that at the beginning of next session. And then as Mr. McNamara pointed out, we have asked for other tools. One is the Comprehensive Energy Plan. And then we've asked for a climate action plan. So I have to, we didn't take those up and consider that aspect of it. But honestly, it makes sense to me that we would, if we're going to ask for planning tools, that we would consult them at a time where we were considering extending standard offer.
Okay, so you're saying the committees didn't actually vote on this specific wording, but on a concept or some similar wording. And that at that point, your understanding was that if you didn't do something now, the program was gone before we got back, and now your understanding is different.
I'm just going to make this easier and say yes.
Good, I made it easier.
I agree,
Okay.
Madam Chair, that this is, the language here is essentially the same as what we discussed last week. This program, when has a tail, and when it's alive, you can make applications and they go out into the future. But on the 1st of January, any new applications are gone because the program ends. And if, as Mr. McNamara said, there are projects that are approved that then don't get built, that those are in the bank and someone else can apply for them. So
Why don't we take a look
why
at
don't
the
we take more
wording?
testimony?
Yes, why don't we take a look at the wording, and we've got a list of witnesses.
Yep.
Okay. And then we'll decide what we want to do with the miscellaneous energy bill. All right. Committee, all right. So Ellen, can you just give us a quick walk through this?
Sure. So Ellen Tchaikovsky, Office of Legislative Counsel. Today, under my name, there are 3 proposed amendments from Senator McDonald. This one that's on the screen right now, draft 1.2, is the language you were just discussing related to the standard offer program. And as Senator McDonald mentioned, it does 2 things. It first, on line 10, raises the eligibility of what types, how large a plant can be eligible for a standard offer contract, raising it from the current 2.2 megawatts or less to 5 megawatts or less. And then the sort of 2-year extension that's being discussed here, there isn't a sunset section in this language, but as Mr. McNamara mentioned, it down here on the bottom of line 21, 10 megawatts per year, starting on April in 2019. So in order to accomplish a 2-year extension, the language on line 14 and 17 raises the overall cap on the program from 127.5 megawatts to 147.5 megawatts, so allowing an additional 10 megawatts per year.
Could I jump in and get clarity here? Because Mr. McNamara, does that mean that next year in 22 we'll see an auction for 10 megawatts? That's what is that what you've described?
That's correct. Yep.
Thanks.
Questions? I'm not hearing or seeing any, so Ellen, let's keep moving.
So that's the whole thing.
Okay, well, let's go on to the next one, because I think, are they different variations, or they're separate proposals?
They were, Madam Chair, one called for a study on a future standard offer that included batteries, which we had discussed before. I put it in there so people could see it. And the third one had to do with a bill that we passed out last year, but got stymied in the COVID, and it never got taken up by the House. And I put it in there just so that people would see other ideas. I'm only offering the first one.
You're only offering the first one. Okay.
It was just described.
Okay, which is basically a 2-year extension. And are you and keeping the same megawatt? Now, when would
yes,
be the last auction under this extension? Assuming that everything got built as it was supposed to, would it be 20?
oh, it would be. well, it would be-
2024?
It would be one, if everything got built as it was supposed to, it would be a year, but if things don't, then they're leftovers and they would go on for yet another year.
Yes, but what year would, with your extension, because we've been told there are that the present program will go through 2022 if there's no leftovers. Would your envision going to 2024 or 2022?
Be 2 years beyond the current
It
deadlines.
would take it to 2024.
Yeah.
And then
Yes,
it would be 25
Yeah.
if there's any crumbs on the plate. Okay. All right.
But people would
Any-
not be making the applications. The original applications and auction would be only for 2 more years. Yep.
Okay. So I'm going to move through our witnesses. Senator Bray.
Yeah, so one thing that the committee was, I think, clearly interested in was the change from 2.2 to 5, but we didn't have testimony on this. And the basic thinking was there's economies of scale to be enjoyed by a larger project. And so might that result in less costly energy being offered in the bidding process? But again, that was theoretical, but that was something that we thought it was worth looking at.
Okay. I'm just not sure this is the committee that should be looking at it.
Right.
Senator Hardy.
I'm going to ask a silly question. I asked it by text to Senator Pearson, and he's searching for an exact answer for me, but I'm thinking Mr. McNamara might have the answer. What does SHIA stand for?
Constrained.
Sheffield Highgate Exchange interface.
Close, export interface.
Oh,
Sheffield Highgate Export Interface.
That's correct. And it refers to Sheffield as the project that was built probably around 2009 or so. Highgate is the converter station that brings power in from Hydro-Quebec. And it's simply noting that those are were at the time the 2 largest resources. And the export interface simply means that there's ISO New England, the system operator for New England, simply draws a line on a map and says the amount of power in this geographic area is larger than what can be safely exported out on the transmission lines during certain conditions. Basically, when it's a very windy day in the springtime with a lot of snow melt and a lot of hydro production, and during the day with lots of solar, all that combining along with the Hydro-Quebec would lead to more generation than can be exported out of this interface.
Okay.
Hopefully that's.
Yes, that is very helpful. I was
For
thinking,
us lay people, it's a bottleneck.
Yeah.
yeah, so that's where we have more than enough renewable energy. And the question is, how do we distribute it around the state so our grid can handle it best?
Or do we move, because running transmission lines is very expensive. And so do we move the generation to someplace else? Hydro is kind of dependent on water, but sun isn't. Wind has more requirements, but generally solar can be located almost anywhere other than my backyard, which does not see the sun. But in most areas of the state, you can site solar without an issue.
And if I, my apologies, if I may, SHII is sort of the poster child for the existing constraints in the area, and we're starting to see constraints pop up in other areas of the state as well. And that's the department's concern with locational pricing, is to avoid the popping up of new SHI in different areas. In other words, you send the price signal of build in the southern part of the state where there's not a lot of distributed generation currently, and that will be less impactful and more beneficial to Vermonters generally. So that's the department's argument for locational pricing.
But we don't do that now.
We do not do that now.
And is that because you do not have the authority to do that, or because we don't have the technology to do that, or what's the barrier there?
Some of it is authority that the PUC has, unless it's changed recently, my understanding is the PUC has stated that they do not have the authority to deny projects from participating in the standard offer solicitation because of location, including in SHI. So any project proposed for SHI would have to then go through litigation. Part of the answer is, honestly, we built up the amount of distributed generation in the state very quickly and to a greater degree than almost any other state in the country. And so at this point, we're trying to play catch up with what are the best policies to continue to accommodate new distributed generation. How do you build this more intelligently than we have in the past? How do you have more intelligent policy that actually keeps up with the grid evolution? Because using the same policies from 10 years ago, it's not working anymore. So we need to evolve our policies.
And is this something that you could come up with by next session to make a recommendation to us?
We
Say
could at
yes.
least, we can definitely have something that is meaningful. To date, nobody has actually, we've talked about this, and honestly, we've kept talking about it in terms of we're doing a comprehensive energy plan that's much more, how do all the pieces fit together? Because we haven't done that in quite a while, and this is a great opportunity to do that. And so, yes, okay, the short answer is yes, we can have a proposal for a locational consideration by next session. I'm not going to say everybody's going to be singing Kumbaya around it, but we can definitely have something.
That's not what this committee almost never sings Kumbaya. I was just wondering if that's an option that we could potentially put on the table. Thank you,
Yep.
Mr. McNamara.
Okay, I'm going to move us through, Senator Bray, unless this is an actual critical question. I've got a room full of witnesses and
No, it's just a lament. We have a bill, S112. We had a predecessor to it last session. It includes locational pricing. It's had no takers. No one in I'd say the development community has been particularly drawn to it, nor the utility world either. But it's so, to Senator Pearson's frustration, I share it. We've seen this problem for years. We have an alternative on the table, and the current systems are, in the end, more attractive to the participants. So now
we're going to move on. I'm going to go right through the witnesses. So the next one is Craig Kenny. Have I mispronounced that? Power Supply Manager for Vermont Electric Cooperatives.
Good afternoon. I'm Craig Keeney. I am the Power Supply Manager for Vermont Electric Co-op, and I appreciate the opportunity to speak to you today. Just a little background, VEC is supportive of cost-effective and well-sited renewable energy. In fact, recently our board of directors made a commitment to being 100% carbon-free by 2023 and 100% renewable by 2030. With respect to the amendment that's on the table, we do agree that there is no urgency at this time to act at this time, because there will be at least an auction at least in 2022 and maybe 2023. So there will be time in the next legislative session to address this. And we urge that you take that time to allow for thoughtful consideration on what is best for the ratepayers in addressing climate change. Having said that, with respect to the wording of the specific amendment, we're against raising the current 127.5 megawatt cap unless the incremental capacity is dedicated to emerging technologies such as small wind or food digesters. We do not see the need to open up the incremental capacity to solar projects or other well-established technologies that have come down considerably in price or are now cost competitive. We also have a few other concerns that we think needs some more thoughtful discussion than the amount of time in the current session allows. We agree with the locational issues that Mr. McNamara raised. We believe, though, that there needs to be stronger language about the consequences of locating in the constrained area. Right now, there's just a suggestion to not go there, or else you can, if you do, you may be subject to some type of payment in order to build there, or maybe getting rejected by the PUC. But we would prefer that the PUC not even have to reject the project because the project wouldn't be proposed there. Another concern we have is equity among the utilities. As you heard, Burlington, Washington Electric Co-op, and Swanton are exempt from the standard offer projects. If this move forward another 10 megawatts or another 20 megawatts, excuse me, we believe that those incremental 20 megawatts should be allocated to all utilities, not just those that are currently purchasing from the standard offer program. With respect to individual project size, I think it might have been Senator Bray talked about whether increasing to 5 megawatts would lower the cost of the projects. We don't have much of a concern with the 5 megawatts, and it is theoretically, economic theory would suggest that a 5 megawatt project could be cheaper than a 2.2 megawatt project. Whether that would happen, I don't know, but it probably wouldn't be more expensive. However, to build a 5 megawatt project, the locational issue now will probably come into a play more often than with a 2.2 megawatt project. The last point I'd like to make is about storage. I got a little confused on a discussion about the amendment. Was the storage part of that amendment or not?
No, it's not. It's not being offered at this time on this bill.
Okay, thank you. Then I won't comment on it.
Okay,
And with that, I'm open to questions.
okay. Any questions for Mr. Keeney? Not seeing any. Thank you.
Okay, thank you.
Melissa Bailey.
Hi, good afternoon. Melissa Bailey with Vermont Public Power Supply Authority. I do have slides if that's useful for the committee, but I do want to be mindful of your time.
How quickly can you go through them?
I can take 5 minutes and just hit some high.
5 minutes is really good.
Great. I think I will go ahead and share my presentation material, and I will probably echo some of the points that Mr. Keeney just made as well. I think from BEPS's perspective, and are you seeing my screen now?
We are seeing it. Yep.
Perfect. Again, Vermont Public Power Supply Authority representing 11 municipal electric utilities. The VEPSA municipals are a little bit, VEPSA is uniquely positioned in that we have experience with standard offer from several perspectives. 10 of our member systems do participate in standard offer and receive the energy output and capacity from the program. Municipal members, Swanton is exempt from standard offer, as has been mentioned from several of the other witnesses. And again, from BEPS's perspective, I think we're grappling a little bit with what the overall goal of this extension to the standard offer program that the committee is considering would be. We are supportive of renewable development, want to do that cost effectively, and we are questioning the need for a state mandated program in order to achieve that renewability. I'm not sure if that is the underlying goal of the amendment. Again, the renewable energy standard dictates how much renewable development we will see in Vermont and how much of that will take place specifically within the state. Again, as you've heard from the witnesses, really the big, I think the rub that you're hearing around renewable development is that location is increasingly important. Our grid is becoming increasingly constrained. We are also hearing there is ample space and ample capacity in the state to continue to develop renewable resources if that's done prudently and with a mind or an eye towards siting. I definitely encourage the committee to also hear from Belco. They're developing their long-range transmission plan right now and have really been exploring where within the state renewable development can occur while minimizing costs and impacts to ratepayers. Again, with the standard offer, you've heard some of this context, and I do just want to make a note that the program was initially conceived in 2009, and a lot has changed since then, right? We have seen solar costs decrease substantially. We would say solar is now a mature technology, and I think I would agree with Vermont Electric Co-op that the standard offer program was really stood up to promote and support nascent technologies, and solar has really, I think, outgrown that that classification. And again, as I mentioned, extending standard offer will not increase the renewability of the electricity that Vermonters consume. So again, those are just some of the changes that we have observed in the past 10 to 12 years. I do want to just take a quick minute to highlight what we see as some of the challenges of standard offer. Again, it's a complicated program. It is administratively complex. There are multiple parties from the Public Utility Commission, VEP Inc., which is the contractor that administers the program, as well as Belco, all have a role in administering standard offer and carrying out the request for proposals and administering the contracts. All of that complexity brings cost. And we question whether that administrative burden is necessary, given that utilities now have a requirement to procure in-state resources under the RES. So again, this is really a conversation about looking at the costs and the benefits of the program side by side. Vermont Electric Co-op mentioned the equity concerns. Again, some of the utilities in the state that are 100% renewably sourced power supply are exempt from the program. And there are some equity concerns there around who's paying for in-state generation. Another issue that hasn't come up that complicates the program is that under the standard offer construct, utilities that have more than essentially their share of development within their territories can then charge the other utilities transmission fees for getting that power out of their territory. And again, so that creates cost shifting among the state's utilities. So although the program was premised on equitable sharing of costs and benefits, in practice, that hasn't necessarily come born to be true. And that's because of disproportionate development in some territories versus other territories. With distributed resources, when utilities are left to their own devices, you would develop a project within your own service territory to keep those benefits with the utility and to avoid having to essentially transmit that power through utility service territories. You've heard a lot about siting and grid conditions. Projects under the standard offer are selected solely on price and without an acknowledgement of the different grid impacts. I'm going to skip over storage because I don't think that's under consideration in the amendment. And I think that this piece about the interconnection maps is also not under consideration, so I can skip over that as well. Again, VEPS's recommendation is that the standard offer program has had a lot of success and should be allowed to sunset as initially contemplated. We haven't heard a clear policy rationale for extending the program. There's still a question in my mind around what the benefits of extending the program would be. And happy to take any questions. I hope that was not much more than 5 minutes.
I don't even know if you hit 5. Okay, any questions from the committee? From Melissa. All right. If there aren't, I can only see three of you, so now I can see everybody. Sandra Hardy, you have a question?
Yeah, just a quick question. Thank you, Ms. Bailey. It's nice to see you. I'm looking at your member utilities. It looks like, is it true that some of them would be under the standard offer or required to be part of standard offer and maybe a couple not, or are they all?
So 10 of our 11 members participate in standard offer, are mandated to participate in standard offer. Swanton Village is exempted based on being 100% renewable, the same
Right,
as
okay,
electric.
got it. I was trying to figure out, I thought there was one, but I couldn't figure out which one it was. All right, thank you.
Okay, other questions? Sandra Bray.
Just a quick one. Can you put a figure on I guess you could call it excess cost due to a lack of strategic locations so the wheeling costs? Do you know what they to the system as a whole, what the wheeling charges amount to?
So wheeling charges are complicated because they're a cost shift. So there's not a net cost. It's a transfer payment among utilities. So the VEPSA members pay roughly $150,000 a year to basically transmit power, wheel power out of VEC's territory, mainly and GMP's territory. But I do want to be clear that that's a cost shift, not a gross cost.
Okay, thank you.
Not, I'm going to go on to Josh Castingay. Josh, are you with us?
Yes,
There you are.
thank you, Madam Chair. And for the record, Josh Castingay with Green Mountain Power, and Vice President, Chief Innovation Officer. So I will be very brief and probably just echoing what the previous witnesses talked about. So basically, we're in the same position. There's actually new, more efficient, I would say, ways to procure renewable energy as we look forward. A lot has happened in the last decade around renewables, the development. We've learned a lot. I'm sure the development community has learned a lot. The grid has changed a ton. And we've already begun to sort of plan for post standard offer to get even more efficient in how we procure distributed solar and other renewables in state, small scale and distributed, so that we can continue to move that forward more quickly. Ideally, doing it in a way that actually gets more built even than standard offer has procured in terms of the pace. So we're sort of getting to the best sited projects right away. The siting is a big thing, as folks have mentioned. If you imagine like the state in two layers, you've got all of the electric utilities, the DUs, the distribution utilities, and all of our electric infrastructure. And then on top of that, you have the Velco bulk transmission infrastructure. And what happens is when projects interconnect at the utility level, they have interconnection requirements, they pay for those upgrades, and they're able to connect. But what doesn't happen is as that aggregates up to the bulk transmission level, slowly over time, you start to hit those bulk level issues, and eventually you can get into those much larger constraints that have much larger price tag or issues. Velco has recently, as Ms. Bailey just said, released a long-range plan showing that actually, when sited across the state the right way, there's still a considerable amount of room to deploy more solar. It's hundreds of megawatts. It might even be like 1,000 megawatts of room if put into the right locations across the state, which is, when you consider Vermont's peak demand is about 1,000 total, and we're already at probably 400 to 500 megawatts deployed. That's a considerable amount that can still be worked in there. So we do a lot around mapping tools and things to try to give as much information to the development community as we can to help with that siting in advance before it gets into the interconnection and permitting process. And I'll just, the last plug I'll make is somewhat related, which is the other best thing we can be doing is thinking about electrification of our transportation and thermal. I know Mr. McNamara mentioned it, but one of the issues, the reason that we have these constraints is there isn't enough load, customers using power to soak up the solar that's being produced in these areas. The more that we electrify and control and manage that load to those solar times a day, the more solar we can build, and that sort of has that growing effect there. So it's a big piece of what we're focused on, as I know everybody is in the space now, is to help decarbonize while at the same time increasing the ability to soak up solar energy across the system. And with that, I will take questions.
Okay, Sandra Hardy, you have a question?
Yeah, thank you. Thanks, Mr. Castagay. So you said that there still is capacity in the state for more solar projects, and I think you said 1,000 megawatts. Did
I
get
think
that
it's
right?
up to that. Yeah. So
Okay.
at the Velco level, I think it's up to about that potentially.
Okay.
Without,
So if the standard offer program is not necessary to ensure the sort of build out of those solar projects, what will encourage and make sure that that we reach our solar capacity for renewables?
So for the utilities, the RES, the Renewable Energy Standard Tier 2 is a key piece there. For GMP, we still have hundreds of megawatts to go just to hit the Tier 2 mark. And you know, our plan has always been to figure out ways to exceed that anyway. But that alone, you know, that dictates how much more we need to absolutely get. And of course, we may plan to go beyond that. But and how we procure that, you know, net metering will have a portion of that. Net metering continues to do its thing and uses a portion. And then we have other procurement plans through RFPs, taking into account location and those sort of things to make it as efficient as possible.
So there are still, for lack of a better term, carrots and sticks that are going to make sure that you get there, or not.
That are
If
so.
we don't have standard offer.
Oh, yes.
The renewable energy credits are a sort of a stick. You have to get to them, and the carrots are doing the right thing, and also the fact that there are projects for you to buy into. I'm just trying to figure out what will make you do it if it's not this program, if we don't renew.
Oh, so yeah, I got you. So yes, of course, you know, as I hope GMP is trying to show, like we plan to exceed this regardless of policy or not. Res Tier 2 is that specific obligation to hit 10% of our total energy demand with a specific class of in-state, less than 5 megawatt distributed. If we fall short, I believe there is what's called an alternative compliance payment, an ACP, that may be in the $60 range, which would be very substantial penalty to everybody if we weren't able to get those projects built and online. So we have no intention of hitting that. And like I said, exceeding our Tier 2 obligation.
Okay, thank you.
Senator Bray.
Good to see you, Mr. Castagay. Just a quick question for people out there who are wondering one of the ways we talk about bringing costs down is competition. So can you characterize the cost to ratepayers of a utility-led renewable generation project versus a developer-led or community-led renewable generation project?
So there's a few things there, because when we think about utility led, there's multiple ways that can happen. There can be the utility builds it, owns it, and operates it. And when that happens, you need to show that the levelized price of that project is on par with however other way you could procure it. Typically, and nowadays, I think we see that right in that standard offer range of 8.5 to 9 cent range. What's more efficient when we look at now to do is do like RFPs. So it might be a utility-led RFP. We're going out to the market. We're saying, you know, a request for proposal, you know, this year, we're going to want to do sort of what we're looking at now. Like we're going to want to do some multi-year approach RFP where there's, you know, could be dozens of megawatts of procurement in there. And then we're going to work those through. Part of that RFP process is going to be showing us the siting information, where are these located, providing maps to show, you know, there's more value here than this part of the state, and how we weigh all that. And then that would be through a competitive process, Senator. So you would expect to see a range of project costs somewhere in that. Again, what we're typically seeing nowadays is in the 8.5 to 9.5 cent per kilowatt hour range currently, and they should all land in that band, I would say.
Okay. Other questions? All right, committee, we've got, a few more. I've got 2 more witnesses, then we're going to take a break. 15-minute break. We're going to come back and do H88. But at some point, I'm going to want someone to move or not move Senator McDonald's amendment, because this bill is going to need to come out too, and we've got a couple of other things. Mr. Murray sent me an email saying that the hydrogen thing was starting to bog the bill down and not necessarily, didn't have to happen this year. He'd like to come back and talk to us. So he'd withdraw his request for an amendment to the bill. I told him we would happily schedule him next year, and we could all learn about hydrogen as a storage or hydrogen storage. But it is a very new technology. So I'm going to move on to Ann Margolis, who is the Deputy Planning Director at the Department of Public Service.
Thank
Ms.
you, Madam
Margolis,
Chair.
the floor is yours.
Thank you, Madam Chair. Can you hear me okay?
It's fine.
Great, thanks. Thanks for having me back. I'm Deputy Planning Director at Department of Public Service. I understand I'm here to answer questions that this committee may have on energy storage as part of H431. I can do that however you'd like. I understand time is pressing. If there's specific questions, I understand there were some questions about what is an aggregation, for instance. I can spend some time on that, or I can also just walk through the latest version of the bill and talk about some of the final proposed amendments.
Why don't you do that?
All right, let me.
And we'll take a look at the latest version.
I don't know if I can, if you want me to share my screen, I think I might just need permission.
Okay, we have draft 11.5, which I believe is what we're working off of. Is that right, Ellen?
I hope it's not 11.5.
I'm reading, it's 1.1. Okay.
Yes,
this one's
but
bigger.
So on Friday, you requested a strike all.
Yep.
So in the strike all are the things that were in the draft from Friday, but also at the end is the language from S56, which is a sales tax exemption from wood pellets. For
Oh, yeah. Okay. Yeah, we did talk about adding that on. Okay.
So there's a lot in this bill because it also does include the language from S128, Senator Pearson's.
This committee is known for its Christmas tree decorating.
All right,
Okay.
and let's see, let me pull up this strike all here. I had not gone back and checked, so I kind of made my own special
That's
version.
okay. Just tell us what we need to know.
Okay, so
We're totally confused at this point anyway.
would you like me to share the strike all on the screen or just follow along?
Maybe share it. I think that might
All right, let me do
be helpful.
my best here.
Because I find I then find myself looking down trying to scroll as you talk. So
Great. Just, can you see it?
yes.
All right, and please just flag me down. I can't see you folks anymore.
Okay.
Sharing it.
I
So-
don't think we got any problem with cybersecurity and not making your cybersecurity plans public record.
Okay, I was going to start with the energy storage pieces, which are my area, if that's okay.
That's good.
Great. So we have this section 3. This is the definitional section. This relates to essentially saying we would like to treat storage the same way we treat electric generation in terms of not having overlapping jurisdiction of regulation. So if storage facilities are going to be subject to section 248, right now that's contemplated for systems that are 100 kilowatts and larger, or if they'll be subject otherwise to the commission's regulation through the rules that are talked about later in this proposed language, then they would be exempt from sort of duplicative municipal jurisdiction. And that's this section 4 as well. I believe, and Ellen, I don't want to speak for you. This was, or for you, Olivia, for that matter, but my understanding is this highlighted language in here and section 4 is really just a clarification. Right now, there's this terminology, public utility power generating plants, that is synonymous with electric generation facilities. And this is just an attempt to make that more plain language and apparent.
Yeah, do you mind if I jump in quickly? So this highlighted language in section 4, you received via email and it hasn't been discussed, but I looked, and public utility power generating plants, that phrase is not used anywhere else in statute. So Rev did recommend just changing it so that it says electric generation facilities, which matches all the other references. So I think this would be a technical correction, but I hadn't put it to you in committee. So that's new.
So if we put in a new term, we have to then define what we mean by the old term, which is by the new term, which makes it different than the old term. And we have not had that discussion.
Well, and actually this is really old language. This phrase, this predates everything. So it actually has been in statute. So, and I don't think there's been an issue previously, but since we are amending this section, it may make sense to just change it now if you would like.
Okay. Okay, let's continue our discussion and keep going.
Right, scrolling down. Section 5. These are our definitions. We're proposing upgrading the definition of energy storage facility here, defining energy storage aggregation and aggregator. There's a proposed change here, removing these words unless the commission establishes a larger threshold by rule. And this was a clarification that was proposed by Ms. Jakowski in order to just essentially not confuse somebody who might be reading the statute versus someone who might be looking to the commission's rules, or trying to have somebody who wants to propose a storage project have to look in two places to determine whether they do or do not need to seek a certificate of public good from the Public Utility Commission. And so this is just saying it's 100 kilowatts and that's it. And this piece is for the aggregation piece. Specifically, there's another instance further on relating to getting a certificate of public good. So there's two different 100 kilowatt thresholds. One is related to if you're an aggregator and you have to get what's called a 231 certificate of public good, as this bill proposes. And that's just to spend a minute on aggregations. The best way the metaphor I can think of it as sort of, you have maybe one big dam that's 100 kilowatts. If it's a hydropower facility, versus 10 kilowatt dams that are all being charged up and discharged, or the water's being stored and released all at the same time, so that the net effect is the same from an energy perspective as that one 100 kilowatt dam. It's the same thing with batteries. You can operate one 100 kilowatt battery, you can charge it and discharge it according to certain signals, rate signals, for instance, saying, prices are low, charge up, prices are high, discharge. You can have the same rate signals going to 10 kilowatt batteries. That is actually what is likely to happen now. We recommended 100 kilowatts as a threshold for some additional scrutiny of aggregations, because 100 kilowatts is the threshold for participating in regional wholesale markets. So the concern here is that you have different rate signals coming from distribution utilities and from ISO New England, the wholesale market operator. The distribution utilities are going to be sending rate signals potentially that are in the interest of their ratepayers, whereas ISO New England will be sending rate signals that are likely to accrue to the benefit of ratepayers region-wide. And those two bodies, state Vermont ratepayers and New England regional customers, do not necessarily have an alignment in terms of when they need those batteries to be charging and discharging. So for instance, Vermont peaks a little bit later in the summer for our annual capacity peak than New England does at this point in time. And so if you have a signal coming from ISO New England to a bunch of batteries that are aggregated saying, we want you to be ready. We think there's going to be a peak, happening at 4 o'clock, for instance. So all of those systems are charging up and they're in Vermont, and then they discharge to meet that regional peak. Well, meanwhile, Vermont tends to peak later, maybe 7 o'clock at night. And if those batteries have all just drained to meet the New England regional peak, they may all immediately charge back up and exacerbate the Vermont peak and the cost to Vermont ratepayers. So what we're saying here with aggregations, and this is just the definition part, but we say it a little bit later, is that there has to be a point of contact where the aggregator who is making these decisions based on various rate signals is having a dialogue with the state, is having a dialogue with the Public Utility Commission. The department would likely be involved in those conversations, and with the distribution utility to say, hey, how are you planning to operate this aggregation? And are there potential negative consequences to Vermont ratepayers? And that's the purpose of the 231 CPG. That's not a siting CPG, a 248 CPG. It's a 231 CPG, which is essentially a certificate of public good to kind of do business in this area. And what we're envisioning here is a light process where it's not, the full-blown process a utility would have to go through to demonstrate it's operating in the public good, but it's at least some sort of a registration process where those communication pathways and that operational regime are scrutinized and on paper. So I went a little further into the bill, but I wanted to just talk about aggregators while we're on them, and they're being defined here.
Okay, Senator Bray has a question.
Okay, so just a quick question. So you want a rational process for sorting out how, to whom, what do they say? No person can serve two masters. So which master is going to direct the charging and discharging of those aggregated resources? And is that going to allow for when the state has actually, through policy and program and things like Tier 3, invested in creating those batteries out there? Is this to help Vermont get its full value out of having made that investment?
So there's a bunch of different parts to your
Well,
question.
you know what? I get the point of it, and so I'll ask you offline more.
Sure.
Learn more.
Yeah, it just goes to the batteries are a Swiss Army knife, as you've heard over and over again.
Yeah.
And batteries really can potentially serve two masters, but they may not be, it depends on really what programs are available to them and what is the best value proposition for the developer of the battery. We're seeing systems being proposed right now in Vermont that are potentially, they're speculative in nature. They are, thinking they're going to build it and then they're going to pursue the most attractive opportunity. Maybe it's a program offered by a distribution utility in Vermont. Maybe it's what's going to come out of FERC Order 2222 and ISO New England. I think they're just sort of building it thinking, or proposing to build projects thinking something's going to come along and I'm going to weigh my options at the time. So we're actually seeing that happen right now, and we want to get ahead of it and try to accrue value to Vermont ratepayers where it makes sense, where the values are commensurate with the costs to ratepayers.
Thank you.
Okay, let's keep moving. I can't see anybody, so holler. All right, let's keep going down.
All right. Section 6, this is just adding in some requirements that would apply to the regulation of storage as well, where we have jurisdiction of public utilities in Section 203. Essentially, it doesn't include storage as a activity right now. So storage is added in there, and there is this clarifying language added here in Section 8 that just says storage has the same meaning as energy storage facility as defined earlier. And I think this was to address a concern that we're not trying to add in a new regulatory requirement for the commission to have jurisdiction over storage of gas, for instance, which is a way, so think of like NG Advantage, mobile natural gas distribution service. We're not trying to add that kind of jurisdiction under the commission. We're just trying to talk about energy storage right here, but we couldn't figure out a very elegant way of rewording this to make that clear, other than to add this clarifying language you see under 8.
Okay, I'm not hearing or seeing questions.
Okay, so these two sections, sections 7 and 8, kind of go together. This has to do with, again, commission jurisdiction. It's very clear the commission's kind of jurisdiction over the activities and sort of the business matters of electric utilities. This is right now basically the third party, the non-utility storage facilities that have come to before the Public Utility Commission and asked for siting permission. So for a 248 certificate of public good, have also come in and said, we're not really sure if we're subject to regulation under sections 107, 108, 109, and 231. So here's all the reasons that we think we should not be. And basically the precedent so far, the decisions have all supported not applying those sections to those non-utility storage projects seeking siting permission. And so this just codifies that. This is meant to ease the regulatory burden on third-party storage projects coming in for a section 248 or a 248J certificate of public good, and saying you don't have to ask for that exemption every single time. It's going to be codified in statute. And this is the 231. This is the requirement being added for aggregators of storage when the aggregation is 100 kilowatts or larger. Again, that's the threshold to participate in regional wholesale markets. This section is just basically saying, if you are not a utility, and a utility is otherwise subject to section 231, so if you're a third party and you're operating an aggregation, you need to come in for some form of a 231. That has yet to be developed. And I understand there were questions last time about the cost burden of this. There's different ranges of 231s ranging from, there's some in the telecommunications space that are very sort of quick and form-based, my understanding, my limited understanding. And then there's the full scope if you want to be a utility and serve retail customers. So there would need to be a process to develop what this 231 looks like, but my sense is it will skew more toward the form-based, quick, not expensive, not incredibly time-consuming process.
Okay. Not hearing any questions?
Madam Chair,
Yes.
I'm not saying I have a question, but we can't hear you. And so you keep coming in and saying, no questions.
Okay, yeah, well, that's all I'm saying. I haven't seen any hands or heard anyone. So we can keep going.
I do have a question for Alan. I thought I don't see the 45 days. We'd had a long chat with Mr. Faber about the default acceptance. Is that still in here? We'd shifted it to 45 days, I thought, and without the default of approval, but.
So that language was part of this subdivision U in section 248. I did not realize that the committee had landed on 45 days. The language that's highlighted in yellow strikes the requirement for the deemed approved on day 31. So if that needs to be changed, I can change that in the next draft.
That was my recollection, but I could be wrong.
Yeah, that's what I remember too, that we came to an agreement on 45 days, but I don't remember the rest of the language changes that we talked about.
I think
because
the request was that we give it, you will respond within X days, which is common.
Yeah. We
but
took out the default.
the
that it was-
default that it's
yeah.
granted, yeah. If 45 is the right number, it's a good placeholder. If they think it's not reasonable, they'll
So
tell
there-
us.
So there's a section later in the bill that is directing the PUC to create a rulemaking on this, to create different rules and registration processes for the different size storage units. And so I also thought there was discussion about whether or not it would just happen as part of that rulemaking, which I think is generally what the PUC does anyway, which when they create the rule, they put that in the rule, but it can be in the statute if you'd like.
Well, it's fine with me if we describe it as something to include in the rule, but we had all agreed on 45 days. So it needs to appear somewhere.
Yeah, we could put as part of the rule that they will establish a time frame in which they will be required to make a decision. Would that work? Or we can put the 45 days in here.
So.
Senator Bray, do you have
I thought the part of, I mean, I do remember the 45 days. I think the PUC's objection was that twofold. One, that they are going to have a rulemaking, but more than that, that we don't usually tell them ahead of time what the number is going to be, and then they write rules. If they're not satisfactory, they can get changed, although that is a painful process at any rate.
a long
Their
process?
Their main objection was, and the House version said, if it hasn't been objected to in 30 days, it's deemed
Right.
issued. That was what they were quite hot about. And so my memory was we took that out and we gave them an extra 15 days.
So Greg from the PUC is here. So
Greg, I
good.
can't see you, but what would work best? And what is the common practice now?
I think Senator Pearson had it right. I think there should be clear direction to us in the rulemaking section of the bill that tells us to develop a simplified process that gets to a decision within 45 days.
Okay. Then, Ellen, if you got that put together, we're good. Okay, we are now. Oh yeah, we're cutting in. I'm going to give you a 15-minute break. So some of the other witnesses, we've got the current use bill for farm and current use coming up. I think we might be able to get that out of here today. But let's get this one finished, then we'll take a break and we'll come back and finish up on current use. Okay. So I guess Ms. Margolis, you're walking us through this?
I'm happy to do whatever you like. I can zoom through it. I don't want to take time away from
No,
Olivia.
I think it's good to hear your perspective.
All right. So we left off.
Okay, well,
sorry.
we're gonna lose Abby at 5, but I don't think we're gonna go to 5. Okay. Let's see if we can wrap this up in about 5 minutes.
Very good. All right, so we have this section 9, is where we left off. This is just updates to section 248. This is the citing where you have to go get a citing certificate of public good from the Public Utility Commission for energy storage projects. So we've made a few edits throughout to basically try to be consistent with the size thresholds for various types of review for storage commensurate with where they are for solar primarily. So I think I can spend time on those, but really the key one here was the 100 kilowatt threshold for seeking a certificate of public good. This was where we were talking about whether there should be a time limit here. Just so you are aware, we had originally proposed just having this be at 100 kilowatts, and some of the discussions in the House resulted in this simplified process for facilities between 100 kilowatts and 1 megawatt. So that was a little bit of a stretch for us going up to a megawatt for that simplified process, but I think it makes sense as long as the timeframes can be spelled out in the rulemaking that's contemplated later. So here is for the section 10 relates to section 8002 of Title 30. That's the renewable programs part of statute. And this is just basically adding a storage definition in there so that storage can be contemplated in programs like the Renewable Energy Standard and Standard Offer, et cetera. And I think this was one of Ms. Jakowski's edits to just say we don't need to repeat the definition here. If I'm just trying to speculate, that we can just refer back to the definition in section 201. And then this is the rulemaking. This is the work to come for all of us this summer and fall. And it relates to creating a set of rules similar to the way we have a set of rules in section 8010 for net metering. This is a new section, section 8011, that really seeks to spell out the rules of the road for storage facilities, both for those larger ones that will be subject to section 248 CPGs, and also the smaller ones and the aggregations. So this relates to a lot of repeated language that you'll see from the net metering section 8010, rules that govern, the duties of the utility and the facility owner of storage or the operator of it. Things like fire safety or their communications to the local fire departments. How's storage reviewed in the interconnection rule that the commission promulgates? How do we measure storage charging and discharging as part of metering? And including when storage facility is paired with a net metering facility, we want to make sure that the storage facility isn't charging off the grid and then exporting and looking like it could be net meter generation and getting compensation for that. How do we resolve disputes? How do we look at aggregations? And also, how are storage facilities paired with these resources like net metering and standard offer reviewed, including retrofits of existing plants? I anticipate that will be a big area of activity going forward. CPG requirements, and then waivers of parts of section 248 that aren't applicable to different types of storage facilities or different use cases. And then this last piece here, section 12, this, I think it needs a little bit of revision here, this utility, but it has a requirement that the commission propose an updated interconnection rule by March 15th, 2022. So this is just kind of putting a date certain on a rulemaking that's currently underway right now. But I think some folks are getting a little bit antsy about seeing that come to fruition. And then that's where I'm going to stop, because that's where I definitely can't speak to that and nuclear decommissioning advisory panel pieces. Any other questions?
Okay, any questions at this
Go
point?
up to the lead introduction to this section, please.
Go up to the top. To which one? The
Where you
section?
started to list the
Storage
various.
facilities, section 11?
Yes.
Okay. But this just says it may implement rules. Is that where you want
Well,
to be, or back further?
Yes, yeah, okay. I'm always wary when we talk about implementing rules which have to do with policy versus implementing rules that have to do with mechanics. And for the most part, I see this list as being engineering and compatible electric connections, etc. And I trust, but I have trusted before and been disappointed that the rules will be limited to such and won't. Well, rules may include provisions that govern. Does this language say mechanical stuff to make connections that are engineering, or does it allow the department to decide what the duties are for owners and operators beyond simply mechanical connections and operational provisions.
I guess I'd like to say it's primarily mechanical, but there's always, I think, one person's mechanical decision can be another person's policy determination. I think a prime example of that is interconnection rulemaking. You know, there's various ways that a utility can look at the interconnection of any distributed energy resource, including storage, and it can be kind of worst case scenario based, or it can be kind of with storage. You know, I think there's a desire on the part of storage developers to have the interconnection of storage reviewed for its use case. So when the storage plans to charge and discharge, and that it will be it will have digital controls to limit the amount of discharge during certain times and not exacerbate grid conditions. I think there's a big question in there about how trustworthy are those digital constraints on that operation. So that will all be fleshed out as part of the interconnection rulemaking process. But I can imagine there's a scenario where somebody would think that they didn't get the outcome that they wanted, and there's a good reason for that, but someone could look at that as a policy outcome. So I think there's going to be some gray areas there, Senator.
Well, maybe the word that got me is that govern, and perhaps that the rules may include provisions that establish standards for interconnection, something, but get rid of that govern word, lest the board think that they're being asked to regulate rather than to establish mechanical standards. So.
Okay.
Okay. Mr. Faber might have a comment here in terms of being at the commission and being the ones who promulgate these types of rules. I mean, they are saying, here's the requirements you need to follow to interconnect safely to the grid. So some of that is regulation, and they may need
rules,
some
provisions necessary to integrate safely with the grid would be satisfactory.
Okay. I think
as set forth in the following.
I
1, 2,
think
3,
they've
4,
got
5, 6, 7.
the message, and we've got one more witness.
Okay, so I hope someone will work on that, Madam Chair, and we can move
Work
ahead.
on that.
So-
I'm going to move us along to Olivia Campbell Anderson, and we're going to lose Abby at 5. So I think we've been through this current use bill. This is the one that talks about windmills, or not windmills, solar on less than 1/10 of an acre. It doesn't get you out of current use. So I think we're ready to vote that out. I could be wrong. So I might just vote that, and then we can go home or to a chairs meeting, which may be over by the time we get there. So Olivia, if you can do this in 5 minutes, it would be great.
Okay, are you sure you don't need a break? I know you guys have been going,
No,
and if it were me, I'd need a
we'd all like
restroom.
I think we'd all like to just move on. I think we're reaching the tilt point of information.
Okay,
So,
I do have one slide that has some relevant information. Could
Okay.
I have a
Yep.
share screen ability? It's set, okay.
there you go. Okay. And this is you're back on standard offer.
Yeah.
Okay. That was just hard to tell by the way the agenda was laid out. So I think it was first come, first served. So the floor is yours.
Okay. All right, so for the record, my name's Olivia Campbell Anderson, Executive Director of Renewable Energy Vermont. I appreciate you allowing me to have some time today. I'm largely here to answer any questions because I know a lot of this is new, but let me just hone in on a couple of very specific things related to the amendments, the concepts of which the Senate Natural Resources and Energy Committee I thought voted 4-1 to support, specifically about standard offer. I also want to thank you for working on this matter in the tax bills. Thank you for taking up the wood pellet and answer any questions about energy storage. So on standard offer, 3 quick points. This slide shows the prices for the most recent standard offer projects. On the left side are the competitive private projects proposed and awarded. As you can see, almost nearly all of them are below 9 cents. On the right side are the utility projects, which were awarded at a notably higher rate for ratepayers. And so standard offer, the very effective, transparent process that it offers, delivers the lowest price solar projects in the state. And it's a very transparent process. That it also, the reason that the issue here is timely is because I know that's of concern, like, okay, can we just discuss this later, next year, etc. Is there is sort of a pipeline or a, I hate using the word pipeline when talking about energy, but for lack of thesaurus, there is a process at the PUC that typically is, you know, anywhere between 4 to 8 months in determining the caps on bidding and the process every year. So it's a docket the PUC undertakes. And there's also a pipeline process on projects. So meaning that it takes time before a bid there's a lot of work that goes into before a bid will even be proposed. Site location, interconnection, grid work, environmental studies, community outreach. So, and that, you know, can take up to a year. So not knowing whether or not the standard offer program is going to continue is sort of will create an awkward gap. And that's why we're asking you to just do a simple extension for 2 years while you continue to do your work as Senator Bray has kindly, you know, committed to do in the
What
committee.
is happening? You are kidding me. You watch on Netflix or something.
Okay, that's not
Somebody
me.
needs to mute.
On behalf of parents everywhere, sorry for that.
Okay, we'll just mute it.
Okay, so so as you saw, already heard in statute, the standard offer program is allocated based on quantity. The statute says that it's 127.5 megawatts total capacity. To date, 112 megawatts have been awarded. And so that leaves 15.5 megawatts left. The PUC has just completed their process for the 2021 bid. And I expect actually that perhaps this week, the bids, you know, it will open for bidding. They're a little behind because of COVID, but this usually happens actually late winter, early spring. It's where in April, it typically opens for bidding. So that's going to happen any day now for 2021. And that leaves then for 2022, again, that process would happen where there's a docket at the PUC and than bids would, but that's only 5.5 megawatts that's left for 2022. This is the latest information based on the total tally. I also do want to point out that standard offer is the only tool right now that exists for digesters, for farm and food waste digesters, which, as you know, are a critical clean water tool and also a waste reduction tool, including notably this year, the Montpelier wastewater facility bid in to stop burning off the methane into the air and actually turn that into energy and reduce climate pollution. If standard offer does not continue, there will be no opportunity for farm digester projects, for food waste digester projects, and for small wind projects. This is the only policy tool that exists in the state for that. And as you know, with any sort of municipal projects or farm projects, it takes quite a bit of engineering and time to make those come to fruition. So that's why we're asking you to create some certainty in the market and give those who are interested, let them know that this will be an opportunity beyond this year. 5 megawatts is not very much, and that is all that will be left for next year. Again, that would be at the, usually it's in April. And then there's a time period for process. And another point I think that's really important from the ratepayer perspective here is that the transparency of the standard offer project is the only tool that regulators have to know the lowest price available for local renewable energy. They can use the standard offer to make judgments about utility proposed projects and what the fair market price currently is. It's really a benchmark to avoid inflated prices that otherwise may come into play. As you can see, the price differential is quite significant between the competitive projects and the utility projects. So I just want to, I think, also speak finally to the other language about the electrical grid and transparency. It looked like there were 3 amendments. One that was a simple extension of the standard offer program. One that would create.
Olivia, those aren't being offered at this time, just the first one.
Oh, okay.
The second 2 are not being offered.
Oh, well, I would encourage them to be offered, particularly the one related to mapping. That's language that the committee passed last year. And if everyone knows the situation of the grid, then we can locate projects that don't require interconnection upgrades that are costly. It's important to note that the project applicant, the developer, pays for all of the interconnection and grid upgrades. There is no cost to the utility or ratepayers or any rate basing of interconnection upgrades. Those are paid and that risk is taken on by the private developer. So it's significant, and the more information we have, the better sited projects can be, and therefore the lower cost for everyone and more time is saved. We don't have the information about the capacity that's on the grid, then projects can't be properly sited. So is there any other questions that you all have related to standard offer or related to the miscellaneous energy bill? I'm here to answer them. I do also really appreciate your inclusion of a timeline on the permits. I mean, there's a lot of language in this bill that regulates, that creates new regulatory burden for energy storage projects. which is an emerging technology that provides tremendous benefits to every ratepayer. And so that includes new permit requirements, that includes new fees that all of those projects will have to pay. And a lot of this technology, even, you know, with ISO New England in terms of aggregation, the rules are not even set. They're not even going to be working on them until at some point next year. So we're kind of seeing all of this as a grand compromise with this entire legislation. We are not opposed to regulation. We just want to have certainty around it, and we want to have reasonable timelines so that we can prepare for those. So appreciate your time, and I'm here for any questions.
Okay, any questions, committee? Senator McDonald. Olivia, if you take the slide down, I can see,
Yes.
there we go. Now I can see everybody.
Olivia, could you put the slide back up again that compares the price paid for electricity from the standard offer program versus the price paid by utilities that buy it on their own?
Okay.
'Cause
Senator,
I'm
I think we saw that.
Okay.
I'm trying
well,
to
then-
move us along.
I
think
know
we
you
s-
are, Madam Chair, and I'm trying to ask a question
Okay.
about what we've been shown. Could you offer us some reason, Olivia, or some practical understanding of why the utilities buy electricity that's more expensive and then send it out to consumers than the electricity that's purchased through the standard offer? Is this because the department is saying we should just let the utilities buy it, and you are saying that when you buy it from the standard offer, it costs less? What are we missing here in the big scheme of things?
Well, I can't speak to utility decisions, but what I do know is that transparency and competition lowers prices. And that's exactly what the standard offer program has done. In terms of utility projects, you know, when a utility owns assets, they earn a guaranteed rate of return that goes into the rate base for the life of the asset. On the standard offer project, utilities do not own them. They don't go into the rate base. And so the entire risk is borne by the private sector, and you're just paying for the price of electricity. I would say that it's quite significant that when you think about the price for these standard offer projects is just less than 9 cents, the value for solar that the Department of Public Service testified to at the Public Utility Commission is just above 9 cents. I think it was 9.2 or 9.4. So when you consider, this is an extremely good deal. Plus the fact that renewable energy credits in the market are worth between 4 and 5 cents is an extremely good deal that you essentially are getting power at about 5 cents. And since it's local power, about 1 cent of that goes back into the economy through property taxes, through local income, and through state revenues. So these are good deals for the ratepayers, and it's good for the larger economy.
So Madam Chair,
Yes.
either Olivia is delusional or someone is arguing against buying the less expensive power and in favor of having the utilities buy more expensive power and then mark it up for the years to come.
Okay.
Is that not a question that we need to answer before we make our decision?
Actually, Senator, I think the decision is going to rest with the Natural Resources Committee, not this one, because it is on future power supply. And I will give the utilities, I think Mr. Castengay is still here with us, a chance to respond. I want to give him some time to find out where those statistics came from.
Well, excellent, excellent.
And then I will let him have a chance to talk to us.
Oh, excellent, because I had a question for him also. Thank you.
Okay.
Yep.
All right. Any other questions for Ms. Anderson? Okay, thank you. I'm going to move us along because I'm hoping this won't
Or
take
is Mr.
more than
Castagay
3 minutes.
Is Mr. Castagay?
No, I'm going to
gonna-
give, he just saw these things flipped up on the screen. I think he needs to have time to find out where those, statistics came from and just to do his due diligence.
Yeah, these are all the publicly available contracts through the standard
Right.
offer program.
So I just want him to be able to go look at those contracts.
I did have a question for him that I thought I might be able to ask. When he remarked that there's not enough capacity to absorb the excess solar being produced. And one of the provisions that I put up was to have a standard offer program that would enhance the ability to absorb solar so that the sun could shine at night. And I believe that the part of the bill that deals with batteries may suffice to move us forward. But the other question was, we have heard several times that solar projects are being approved in the SHIA and they are wasteful and costly. Olivia was going to speak to the applications in the SHIA that had in fact been rejected by the PUC and were no longer being approved in the SHIA area. And she didn't speak to that, but could she help us understand whether that is in fact the case?
Sandra, I'm not clear what your question is.
Okay, we have heard a lot of testimony from the department about how the PUC doesn't have the authority.
Okay, we're talking about to Mr. Chastengay, who represents Green Mountain Power. Do they have one of those contracts? Or are you asking him if his contracts? I'm not sure what you're asking, Mr. Castengay.
So, forgive me, Madam Chair. I thought Mr. Castengay was going to speak and answer some of the questions that Olivia had brought up, but
no, I said unless he wants to, I'm going to
Okay.
give him a chance
Absolutely.
to look at it. He lit up and you said you had a question. I'm trying to figure out what the question is for him.
Since he was not going to speak now and was going to gather his thoughts, I thought I would wait to ask him a question. And now I would like to ask Olivia the question that I posed.
Okay, I am going to have to move us on because I'm losing my legal counsel and we are not finished with this bill.
Okay.
So we will be back to this. Mr. Castengay, do you have anything to say at this time?
I guess thank you, Madam Chair. The only thing I would say is we provided, I believe just before the hearing today, an update to the committee on the standard offer projects, because there's a little bit of a misunderstanding in the block that's called competitive block. The lowest price project, which is called Bristol, I believe, I don't have it in front of me, unfortunately, 8.7 cent project, is a GMP provider block project. Again, it's a PPA that we did with a developer and then proposed that in the provider block. So I just wanted to make that point clear. In 2020, that was one. We also have another one in there. And then a few more in that list actually have dropped out since and been replaced with slightly higher price projects just over 9 cents. But I just wanted to make that point. I believe there is a single document in front of the committee that lays that out.
Okay.
So do I understand Mr. Castengay's testimony to be that standard offer prices are not lower than the prices paid by utilities to purchase solar?
I'm sorry. So standard offer prices are not lower. I apologize, Senator McDonald.
I didn't understand that either.
I'm
as
sure
your
that
answer.
it's my error. As having reviewed the purchase price of solar power under the standard offer and the purchase prices made by utilities for solar power, which of those two provide solar power at the lower prices?
I would actually say over the last few years, they've been very similar to about the same amount. We expect, whether it's a PPA that we're doing directly with a solar developer or through the standard offer, that we should be coming in that upper 8 cent to 9 cent range. The lowest price project that got into standard offer this year was 8.7 cents because of work GMP did to negotiate with a developer to get it to that point and propose
Okay,
it.
I've got chats coming from other witnesses, contradicting witnesses, and this is not helpful. I'm going to give Mr. Castengate time to go look at that document and come back. The testimony that's been flying up in chat says the GMP is not involved in that list. So I'm going to let you go, do your research and due diligence, and then come back and give it. I don't think it is fair to spring a document on someone. And we do not have witnesses debating witnesses here. This is testimony for the committee. So I am going to move us on to our next and final item, which I hope is voting on H88. And I hope is a lot less complicated. And thank everybody that's been here. And we may or may not take this one up again. All right, because we are running out of time. So Abby, are you with us? You
I am.
are. Hi. This is the 1/10 of an acre solar. Okay, I thought it was. So did you have changes that we asked you to draft in this?
Yes, so I have
Okay.
shared with Faith, and there is amendment language that the committee had discussed to the very first section, so not the section about allowing the solar array.
Okay,
I
so
can pull that up
why don't we
to
put
share.
that up?
And
we'll
for the
take
record,
a-
Abby Shepherd, also Office of Legislative Counsel. I'm sorry, I forget to do that with my being at home, but let
Not the
me
same.
share this language
There's
with
no
you.
sign on the microphone in front of you. Okay,
Great. This should pop up. Okay, great.
there it is. Okay. Did we lose Abby? Okay, we got the screen share, but we seem to have lost Abby. So give her a minute or two to come back on. Uh, Faith, have you heard from Abby at all? Well, you're moving, so I know it's not just me that's frozen.
I haven't heard from Abby. I'm sorry.
Lost Abby. Senator Sirotkin.
So I've been in communication with Abby and several other committees. This, which I think she was about to get on, I don't know if you can move the screen up at all, was that little issue about current use, about the language being too open-ended
that people could not file their certifications.
Oh, yeah, okay, yes, with the commissioner that,
She came up with some
and-
language and she can explain it, but it's pretty straightforward. It was Senator Pearson at the very end said, why don't we just say after November 1st? And that's what the language does.
Faith has now put it up. Use value under the subchapter on or before November 1st. Right?
Right.
Okay, here's the change at the bottom. In the event the owner of the agricultural land or building enrolled in the use value program fails to certify on or before November 1st of each year as required under the subsection, the commissioner may waive the certification requirement provided the commissioner obtains through other means satisfactory information that the agricultural land continues or agricultural buildings continue to meet the requirements for enrollment. Abby is back. Senator Sorokin, this was your issue. Does this do it for you?
It does.
Okay.
I think I reviewed the principle with Senate Ag and nobody objected this morning.
Okay. So that's clarifying language. Abby, are you with us?
Yes, I apologize.
Okay.
That's not how I got
Internet
bumped off.
internet problems happen. I think we like your language.
Okay.
Senator
great.
Sorokin has given it the stamp of approval and it was his issue. Committee, any other questions on this one? Concerns?
Just a quick
Right
question.
now, yes, Senator Bray.
I saw the word commissioner, but so that's Commissioner of Department of Tax?
No, Forest
correct.
Park. Yeah, it was a
No,
tax. No,
this is tax. Yes.
tax. Okay. That's right, Forests and Parks, right. Too many commissioners in here the other day. Okay, it is the Commissioner of Tax. So, committee, if we have no questions and nowhere to go, a motion to amend might be in order. Senator Pearson,
I move we amend H88 with draft 2.1.
okay, is there further discussion on this? If not, Abby, can you take it down so I can see the committee for a vote, or Faith, whoever has it up? There we go. Okay. Senator Hardy, you have a question.
Yeah, I just want to, for clarification, are we amending with the amendment we just talked about, the Committee on Agriculture's bill? Is that what we're doing? Okay.
This is its own separate amendment because this does not change any of the sections that are in the agriculture amendment. So this is actually amending the underlying bill.
Oh,
Okay.
I'm sorry, that's what I was saying when I thought I was still on the Zoom call.
oh, okay.
Apologies.
Okay.
But it's undermining the underlying bill as proposed to be amended by agriculture, correct?
Right. We're not amending agriculture's amendments. We're amending the bill.
We're amending the House bill.
The House bill
Ag Committee also added to the House bill, but didn't change it. Is that what you mean, Abby?
It's because each committee is amending a different section of the House bill. So it's two separate committee reports on the same bill.
Yeah.
Right,
I mean, it
'cause
doesn't really
neither of
matter.
them
We're
are
amending
strike
what
all.
came to
They're-
us.
No, it is not a strike all.
Right,
That's
okay.
Okay. Further discussion?
Is it,
If not, Senator McDonald, you had a,
no, I was wanted the draft number as the clerk, that's all. So
oh, draft
Just
number.
2.1.
Process-wise, we're not going to take a position on the agricultural amendments.
Don't usually.
Date,
Our domain really is the taxability of the land.
No, I understand we
Yeah.
don't necessarily substantively take a position, but process-wise, I thought we had to amend the bill as amended. On the floor, we're going to have to do that. one of these amendments is going to have to come first, right? So they either further amend what we do, or we amend what they do. Doesn't matter. We'll get there.
John
Will be
Bloomer will tell
subsequent,
us.
Madam Chair. Such an amendment would come after we do this one.
Okay.
And the date on draft 2-1 is?
5/11, today's date.
Thank you very
Senators.
much.
Okay. Further discussion on the amendment? If not, all those in favor say aye. Raise your hand.
Aye.
1, 2, 3. I'm seeing there's 7 of us. 700. Okay, that's the amendment. The what? Yeah, 1.1 acre is in the bill, the House amendment, right? Or the bill as it came to us amended.
So the 0.1 acre is in the Senate Agriculture Committee's amendment.
Okay, so we need a motion. No, we don't need to amend that. We just need to approve the bill as we have amended it, right? Because the 1.1 acre is already in. Right, the House, the Ag Committee put the 1.1 acre in. We've changed, upgraded the wording in the first part. Now we just need to move a motion to approve as amended.
So move, Madam Chair.
Senator McDonald has moved that we approve as amended. Is there further discussion? If not, all those in favor say aye.
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 Opposed say no. I'm seeing that as 700, and I am seeing a truly worn down committee.
Just getting started, Madam Chair.
Oh, I'm going to tell you all to just go in peace tonight. I don't know if any of us are ever going to make it into or if they're even trying to hold a chairs
It is.
meeting, since half the chairs are sitting here and the minority leader. I told them I thought we would still be meeting. So we can try and get in, and thank you. We've done yeoman's work today. So I'm going to put 431 back on tomorrow. We've got S53 as it came back to us, all the tax changes, just an initial walkthrough. And then on Thursday, we'll do one, we'll go back to 431 and see if we can get that one out. We also have the miscellaneous revenue bill, and I'll try and get that on Thursday too. Senator Sirotkin, did that get attached to a House bill, and is it, or Senate bill, and coming back to us?
It'll be coming back probably on Friday it's already passed out of passed out of natural resources, and then Ways and Means, and it's up tomorrow in appropriations.
They're
So-
putting a revenue bill on a natural resources bill?
Yes.
That doesn't sound overly germane.
Right.
So we will try and get the revenue bill out. Or we'll hold it for next year, but I know they would like to get that out, and I haven't had a chance to talk to Representative Ansel to find out what was going on. So, Senator Hardy.
Sorry, this is a question on a different topic, but did you all get an invite to a joint meeting about the telecom plan?
I haven't looked at my email in the last hour or so.
Okay. It came this morning, but I can't quite see the whole thing, so I was wondering if you all got it. It seems to be in June. At first, I
Can
thought
I
it was
take
this
you off live?
Okay, yeah, let's take us off live because we are now